Hello, welcome everybody. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal, and thank you very much for joining us today for our webinar on things you should know when buying or selling residential property in Victoria. Before we get started, we'd like to briefly acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respect to their elders, past, present, and emerging, and extend this respect to First Nations communities throughout Victoria and wherever you may be logging in from. So again, welcome. I know many of you have attended our webinars before, so welcome back. And if it's your first time, then a very special welcome. Thank you for joining us for the first time. We really hope these webinars are a really useful resource for you. It's an opportunity for us to share some information and insights of things that we're finding in our day-to-day practice that we think are useful to share. And you can also catch up with the recordings of not just this webinar, but all our previous webinars by heading to our website and looking for the resources page. Our lawyers over the last couple of years have done a number of webinars across our whole firm, from not just property law, but also commercial law, wills and estates, disputes and employment law, and so on. So if you're not very familiar with our firm, we have a number of accredited specialist lawyers across some of these areas. So we are able to go into these topics with a lot of detail and real expertise and experience. But as I mentioned today, we're looking at buying and selling real estate here in Victoria. So I'm joined today for our webinar with Andre Ong, a principal here at Sharrock Pittman Legal, Senior Associate Shubha Rao, and also Loren Stojcevski, all from our property team. And they're dealing with these sorts of issues day in, day out. And I know they're looking forward to sharing their thoughts and insights with everyone today. So before we do begin, I will just run through a couple of housekeeping items. So we are recording the session, so don't worry if you miss something. We'll make the link available very soon once it's up online. And if you do have any questions throughout the session, feel free to type away in the Q&A function. We'll either address them in that Q&A box or during the webinar itself. We've set aside some time at the end for questions, but we're conscious of your time. So if you do reach the end of the hour and we haven't gotten through all the questions, don't worry, we'll keep track of them and we can get back to you afterwards. We'll also share our contact details again at the end, so you can note them down if there's anything you want to get in touch and speak to the team about. And finally, we're lawyers, so we've got to have some fine print. Obviously we can only talk about things in a general sense today. Property transactions can be deceptively complex, and they can swing a lot on the particular circumstances about the property, the contract, and so on. So this is deliberately very general and also aimed at both buyers and sellers. So if there's anything that's a burning issue for you, do get in touch and get some advice. And obviously we're also talking about things here in Victoria as well. So I'll hand over now to Andre, who'll start taking us through today's content. Thank you, Andre.
Thank you very much, Mitch. So today we're just running through some of the common trips and traps that people might run into when they're buying or selling homes or residential property. It's been a little while since we have done a residential session, so we thought it might be a good time to catch up, as we are seeing a few different trends out there in terms of issues that vendors and purchasers are running into. So just covering off what we'll address today. Owners corporation issues, common issues there that we're encountering, both when we're preparing contracts and vendor statements for vendors to make sure that they're fully binding. If you make some critical errors there, that can be definitely fatal sometimes in terms of a contract being able to stand up. And with purchasers as well, when they're looking at buying something that is impacted by an owners corporation, what do they need to watch out for so that they know what they're in for whilst they own the property and are subject to that owners corporation whilst they're there. Pest and building inspections, there have been a few developments there, not least of which the standard contract now has some terms in it that agents will often just tick the box on. How does that actually work? Then there's the subject of finance provision in, I guess, a little bit more of a fluid property market at this point. We're seeing more finance clauses than before, rather than just people signing off unconditionally. In that sort of scenario, there has been a recent case that's impacted what people need to think about when they're completing that. And then there's some some owner builder work issues. That's always a perennial obligation that people have to address. There's often a lot of uncertainty or misinformation out there as to what people need to actually do to comply with those obligations, and if you're a buyer, what you need to watch out for. So we'll cover off that. And we'll round off with the Help to Buy schemes. The government has obviously done their bit to tried to do their bit in terms of trying to help buyers onto the property ladder. So we'll work through some of those new schemes that are in play. And then we'll have some time at the end for some Q&A. But as Mitch has said, feel free to type into the chat box, and I'll be there jumping in and trying to address your questions as we go. So I will hand off to Lauren now to run through owners corporations.
Thanks, Andre. Hi, everyone. My name's Lauren. I'm one of the property lawyers here at Sharrock Pittman Legal. Firstly, I want to focus on some of the recurring issues that can trip up vendors and purchasers when it comes to owners corporations and identifying common property. So when we're drafting contracts for a vendor, one of the most common instructions we get is that there's no owners corporation. But when we order the title, we find that there actually is one registered, which often surprises our clients. It's an easy mistake to make because in Victoria, an owners corporation, or an OC, which I'll refer to it from now on, is automatically created when a plan of subdivision that creates common property is registered. It comes about by operation of law under the Owners Corporation Act, which means that if you're in a property that shares, say, a driveway or a garden or an elevator with your neighbours, for example, then you're automatically a member of the OC with financial and legal responsibilities to it, even if you didn't opt into it. So that's where the first pitfall arises for our vendor clients, because under Section 32F of the Sale of Land Act, the vendor statement has to disclose certain information about the OC, which is usually contained in a Section 151 certificate that complies with the Owners Corporations Act. If there is an OC registered on title and it's not disclosed properly, then the purchaser can actually terminate the contract of sale. And in larger developments like apartment complexes, for example, the OC manager would often prepare the certificate, but in a smaller 2 or 3 lot subdivision, that responsibility often falls to the vendor. Next slide, please. Thank you. When a vendor says that there's no owners corporation, oftentimes what they really mean is that it's inactive. It will be inactive if in the last 15 months it hasn't held any meetings, struck any levies, or taken out insurance. If that definition is met, then the vendor statement can just state that the OC is inactive, and that will be sufficient disclosure to make the contract airtight. But deciding that an OC is inactive is the beginning of our inquiries rather than the end. It's important to check the plan of subdivision to see if there's actually any common property that exists, and then ask whether the OC is actually required by statute to have insurance. Next slide, please. That's the next major issue. If there are 3 or more lots and there's common property, then the OC is supposed to have reinstatement and replacement insurance for buildings on the common property and public liability insurance as well. If it doesn't, then Section 11 of the Sale of Land Act allows a purchaser to end the contract at any time before settlement, which leaves the vendor vulnerable. So in practice, would be advising our clients that either they or the OC need to get the insurance in place before we prepare the contract. Having said that, once they have that insurance, that means that it can no longer actually be considered inactive, which then triggers the obligation again to provide a Section 151 certificate in the vendor's statement, and failure to provide one will make the vendor's disclosure defective and once again give the purchaser a right to terminate. There are some exceptions to this. For example, where there is no common property and lot owners have all formally agreed to arrange their own insurance. And likewise, OCs for 2-lot subdivisions don't have the same insurance obligations. But even in a 2-lot subdivision, if there is any common property, there are still risks to the owner because financial liability doesn't just disappear because the OC insurance wasn't mandatory. So in practice, we often advise vendors to speak with their broker about taking out public liability cover for the common property before they sell. So overall, the key takeaway for avoiding pitfalls when acting for a vendor is to never assume that there's no owner's corporation. Read the plan closely to identify any common property. Consider whether insurance is actually required by statute, and then start drafting the contract. Next slide, please. Now, on the purchaser's side, the most common mistake is failing to properly read the OC material in the vendor statement before signing the contract. A compliant vendor statement usually includes a Section 151 certificate, owner's corporation rules, and recent AGM minutes. For these documents, purchasers need to understand their lot liability and entitlement, which basically determines their voting power and also their contribution to annual fees and capital works for the OC. You want to make sure that your liability is proportional. Otherwise, you find yourself in a situation where your lot is, say, 5% of the overall area of the development, but you're actually paying 20% of the total costs. And changing that after settlement would require unanimous approval from all the OC members. So for example, we've had a prior matter where a client came to us showing that there was an error in their lot entitlement after settlement. So unfortunately, we had to advise them that it wasn't something that could be changed because of the unanimous approval requirement, which then makes it an issue of liability for the vendor. There's also a risk to purchasers if they don't understand that further fees might be payable. For example, when the contract includes a special condition that special levies raised between signing the contract and settlement will be the purchaser's responsibility. So if they get pre-contract advice, that risk can often be negotiated, because a close reading of the annual general meeting minutes can actually raise any alarm bells for foreseeable costs. For example, the minutes might refer to something like building defects or combustible cladding investigations, elevator replacement, water ingress issues, or upcoming litigation. And a careful review of the vendor statement and frank discussions with the purchaser can help them make an informed decision about whether it's actually feasible to proceed with the contract. And that's why pre-contract review is often critical. Next slide, please. Finally, for both vendors and purchasers, a lot of problems arise from misunderstanding lot boundaries. And it's an easy issue to avoid as long as you remember that boundaries of lots in common property are determined by the plan and not actually by what appears on site. So these days, most properties are registered on a plan of subdivision, but if the property was registered before 1988, it might actually be on a strata plan instead, which follows slightly different rules about interpreting lot boundaries and what counts as common property. And those differences will depend on how the surveyor originally drew the plan. So to avoid pitfalls, we need to identify whether the property is drawn on a modern plan of subdivision or if it's an older property that still has a strata plan. Overall, across both sides of the conveyancing transaction, the main thing to watch out for is assumptions. So assuming that there's no owner's corporation, assuming that the owner's corporation is inactive, assuming insurance isn't required, or that quarterly fees tell the whole financial story, assuming physical occupation reflects the legal ownership, and assuming the plan is a plan of subdivision rather than another form of document. Moving on to the next topic, another common mistake is treating the building and pest inspection clause in the contract as an afterthought. Generally speaking, if the contract is conditional on a satisfactory building and pest inspection, that means that the purchaser can terminate the contract to get their deposit back if a defect in the structure or an infestation is found on the property. Most purchasers just think that if they ask the agent to tick the relevant box in the contract particulars, which you'll see on the slide here, they think that they'll be protected. But under the standard LIV and REIV contracts of sale that most people use, these conditions are actually very technical. And if the general conditions aren't fully complied with, then termination rights can disappear even if there are actually serious issues with the property. Next slide, please. There are 4 key considerations for the purchasers. So who can prepare the report? What's a major defect? What's the time frame for exercising the right to terminate? And are you in default? Next slide. So the first mistake is asking the wrong person to prepare the building and pest inspection report. Under the newest 2025 September LIV general conditions, the report has to be prepared by someone registered under the Building Act, which includes a registered building surveyor, building inspector, domestic builder, or architect. And what often happens is that a purchaser hires someone who says that they're a building inspector, but they're not actually properly registered. They might be experienced, but if they don't meet the requirements under the Building Act, then the report automatically doesn't comply with the contract and the purchaser loses their termination rights. For pest inspections, the updated LIV general conditions don't require a particular person to complete the inspection, but the report and inspection still have to comply with the relevant Australian standard. Next slide, please. The second mistake is assuming that any defect will justify termination, but unfortunately that's not the case. Under the Australian Building Standard, a major defect is one that requires rectification to avoid either unsafe conditions, loss of utility, or further deterioration. So essentially we're talking about structural issues rather than cosmetic paint cracking or maintenance issues with appliances or wear and tear more generally. The Court of Appeal said in Willis and Crosland that the report has only two requirements. One, it has to identify a current structural defect, and two, a registered building practitioner has to designate it as a major defect. So basically that means that it helps if the report uses the exact wording major building defect, because that's what the contract says, but it's not actually technically necessary. In this case, the inspector just said major defects were on the property, but the court looked at the report in context and decided that it was obviously talking about major building defects in the structure rather than the land, which was enough to meet the contractual requirement to let the purchaser walk away. But having said that, in practice, we prefer to take a cautious approach. When we refer to a purchaser or refer to a purchaser to a building inspector, we make sure that they understand the contractual requirements of the Building and Pest Inspection Clause, so that if the purchaser wants to terminate, there's no ambiguity or argument about whether they're actually entitled to do so. Next slide, please. The third pitfall is timing. So the standard general condition gives you 14 days from signing the contract for the building and pest inspection condition to be met. So in order to terminate, the purchaser only has 2 weeks to have the inspection done, get the report, and then serve the vendor with a copy of the report and their formal notice of termination. And given that it's very common for the vendor to include special conditions that actually shorten this time frame to 7 days, that actually adds a lot more time pressure. The fourth pitfall is default. So to rely on the building and pest inspection, the purchaser can't be in breach of the contract. For example, if the deposit is paid late, they might lose their right to terminate under these clauses. So it's an easily overlooked but critical point, which is why we try to make sure that the deposit isn't due until after the building and pest condition has expired. Overall, from a purchaser perspective, this is where pre-contract advice really adds value, because we can negotiate a broader condition. Like, say, for example, instead of making it refer to a major building defect, we can say that the contract is subject to a building inspection that's to the purchaser's satisfaction, which lowers that threshold. And strategically, even if there is a major building defect, then termination isn't actually always the best outcome. In practice, these clauses actually operate more as a commercial leverage to negotiate a price reduction or require rectification before settlement. Switching to the vendor side, if a purchaser's report shows a major defect or an infestation, simply agreeing to let the purchaser terminate doesn't necessarily solve the problem for them. It often just delays the inevitable, because the next purchaser is just as likely to get their own report and uncover the same issue. So more importantly, once the vendor is aware of the defect, their risk profile changes. If they actively try to conceal the defect or the infestation, or they don't disclose it properly, they might actually be exposing themselves to liability for material fact non-disclosure under Section 12D of the Sale of Land Act, which can leave them vulnerable to significant fines and even, in some cases, up to 12 months imprisonment. So for that reason, it's often commercially sensible to advise vendors to either fix the defect before settlement or address it before remarketing the property. I'll now pass over to Shubha to go through some other issues.
Thank you, Lauren. Good morning, everyone. Today, I'll be discussing the topics of subject to finance and owner-builder works. Well, subject to finance, what does this mean? It is essentially a way out of a contract for a purchaser if the purchaser is not able to secure sufficient loan funds for the purchase. This is a condition that benefits the purchaser only. Once exercised, an election by the purchaser to terminate the contract for finance is not irrevocable. So it is a very important decision that needs to be made at that time. So how does the actual condition operate? So mainly there was a clause that was there in the 2014 Law Institute General Condition, and now there's one in the updated 2025 General Condition there. The subject to finance terms are usually contained wholly within these general conditions. However, there are some firms that include additional provisions as well by way of special conditions. Everyone just needs to sort of remember that once a contract is fully signed, the terms are binding and cannot be unilaterally changed. So all parties must be satisfied with the conditions that are being included in the contract. Next slide, please. So this is just an extract from the 2014 General Condition, where people, so together with the agent, the purchasers would include the details of the lender, the loan amount that was actually going to be applied for, and the proposed approval date there. Next slide, please. So with the actual general condition, this is what was required of the purchaser in terms of that they'd have to immediately apply for the loan, do what's required reasonably in terms of obtaining the loan approval. And if you're going to terminate, then you have to serve return notice within a certain time period that's there and not be in default. If you could go to the next slide, Mitch. This is the 2025 general condition that's there. So it's similar to the 2014 one. You still have to tick the box to say that you want the contract to be made subject to the loan. You have to include details of the lender. Over here, it's got the words or another lender chosen by the purchaser. So if there is a need to substitute the lender, the purchaser is able to do that. And also in terms of the difference between the two clauses, the loan amount here refers to the words no more than. So it includes a cap on what the loan amount you're going to be applying for is. It's important for a purchaser to liaise with their banker or the broker to understand how much actually needs to be borrowed and include the correct amount here with, some buffer being included there because there's a cap and you don't want to go over the cap. Also, in terms of this 2025 one, the written notice that's there in terms of terminating the contract also requires evidence to be provided from showing that the loan has actually been rejected or has not actually been approved there. In practice, there were many firms that were sort of using the 2014 loan terms that were there and that would include general condition, special conditions for respect to the evidence to show that the loan could not be approved. Some of them would also have conditions to specify exactly what type of written evidence they would require, and they would not accept a letter from a mortgage broker, for example, and they'd want something directly from the bank. From a purchaser perspective, if we see any of those types of special conditions, we actually do need to understand if the lender that you're going to be applying for actually does provide rejection or non-approval letters in that format. If it does not, then we'd actually have to negotiate different terms with the vendor there. Otherwise, you won't be able to comply with the terms. From a vendor perspective, the vendor can try and include more control in terms of placing these types of limitations there so that in terms of any purchaser that makes an offer, only more genuine types of purchasers will come through the door, and there's probably a greater likelihood that their finance might be approved. So in terms of the key compliance requirements, the first step would be to immediately apply for the loan. There have been instances where purchasers have signed up a contract and they've gone to a broker and the broker has said, there's just not possibility in being able to get through the loan that's been put there. There is still a need for the purchaser to apply for the finance, even if it's actually going to be rejected. Failure to apply is going to be a breach of this condition and you won't be able to terminate the contract on that basis. The next step is to do everything reasonably required to obtain loan approval. The third step is to terminate. If you're wanting to terminate the contract, you have to serve the written notice within 2 days after the approval date. So it is important to note that if a vendor consents to an extension of time, usually practitioners will remove this 2-day grace period. So on any extension, you pretty much have to terminate on that extended approval date. And also, you're not to be in default of the contract at the time of serving the notice. As Lauren mentioned earlier, with respect to the deposit, if there's a deposit that's required to be paid prior to the loan approval date, the purchaser does need to pay that money in, or otherwise it won't be able to rely on the contract later in terms of exiting. We have had calls from purchaser clients who are a bit cautious about wanting to pay money to the vendor, if they're unsure about their finance outcome. We do reassure them that they do need to do that in terms of being able to then seek to rely on the clause and terminate. So we do say, in terms of at the time of negotiation, purchasers should say, can ask for the deposit to be paid for, say, 3 business days after finance approval being received, instead of actually putting a fixed date into the contract there. So it gives purchasers flexibility and the time to be able to make the payment once the approval has been received. Any extension request as well for in respect of the deposit payment should also, in respect of the finance approval date, you can also ask for an extension of the deposit payment date to align those 2 amounts as well. Vendors can also ask for to grant an approval for the extension of the approval date, but they would still might want the deposit to be paid on time. To show that the purchaser is a genuine purchaser there. But usually we see this happens after 1 or 2 extensions of finance have been granted, and the purchaser is asking for another one at that point. Next slide, please. So these are just a couple of cases that have discussed subject to finance points. So in this case of PUT and Perfect Builders, here the purchaser's application for finance was for an amount that was $1,000 higher than the sum that was actually nominated in the contract. So this was the old contract where you just put a fixed amount was put in there. So the court determined here that a purchaser who enters into the contract subject to finance must act reasonably and without delay in fulfilling their contractual obligations. The court found that it was not satisfied that the plaintiffs have actually applied for the loan of $475,000 in compliance with the actual condition in the contract, and also that the purchaser had not done everything that it was required to reasonably do to obtain loan approval. The purchasers had given some correspondence to indicate that the lender had required further information from them, but no evidence had actually been provided as to show what the actual requirements were and how the purchasers attempted to meet them. In the next case of Pearl, this was the old General Condition 14, the 2014 one that was that applied in this contract. Here, the contract was requiring a loan approval from HSBC for a loan of $1.5 million with a finance approval date of 10th of April 2020. The parties agreed to extend the time of approval to 20th of April 2020. And on 20th of April, another extension was sought, but this was not granted. So in this one, the purchaser ended up applying to AMP instead of HSBC. And so because of on the extension here for the 20th of April, when an extension was sought for the 27th of April, the purchaser did not actually serve any notice to rescind the contract there because it thought it was under negotiations with the vendor in terms of granting that extension that's there. So the purchaser was caught out because the rescission notice it served was on the vendor served a rescission notice on the 4th of May to terminate the contract there. So the contract became unconditional and then the vendor sought to terminate the contract there. So the court here looked at, because the termination notice in terms of the finance approval was served beyond the 2 days, the contract was unconditional and it didn't need to sort of look beyond that in terms of whether the vendor was any arguments of estoppel or anything like that. In the next case of Umbers, this one was a sale of business contract, but the finance clause was very similar to what we have in the residential ones. Here, the general condition is similar to general condition 20. The approval date for finance here was on the 17th of July. And on the 18th of July, the purchaser's representative wrote to the vendors indicating that finance had not been approved and requesting an extension to the 17th of August. And if they said if the extension was not granted, then that letter of the 18th of July was to be treated as written notice terminating the contract. The court, however, found that that notice was actually not a termination notice, and the contract remained on foot, and it was became an unconditional contract. It was very commonplace for practitioners to issue these types of letters in terms of seeking an extension and then indicating that if the extension is not granted, then the contract is terminated. So in this way, the practice of how these were done needed to be changed and terminations needed to be done, or extensions needed to be asked well ahead of time so that a response could be received from the vendor and a decision made by the purchaser as to how they would like to proceed. In this last case of Shubha Rao, this was a Northern Territory case, and here the purchaser failed to apply to the nominated lender on the contract, and they applied to a substitute lender. So the nominated lender was AMP, and they applied to CBA instead, and they also applied for more money than was listed on the contract. So the judgment was found here for the vendor, and the vendor was allowed to obtain damages for the purchaser's failure in terms of not complying with the actual terms of the loan approval strictly. Next slide, please. So in terms of access to the property by a valuer, so the vendor, without a special condition in the contract, a vendor is not obliged to grant access to a purchaser, except for a final inspection of the property. It can be argued that if the contract is subject to finance, that the vendor has an implied right to grant such access to the valuer to be able to assess the purchaser's application. A vendor is still not, however, required to make a property available to the purchaser's financer to undertake investigations as to the physical characteristics of the property. With respect to limitations on the purchaser, a purchaser cannot seek to use their right of inspection prior to settlement to give a valuer access to the property to assess the finance application there. So in terms of dealing with this issue, on a purchaser side, access rights should be negotiated as part of the contract. For a vendor, cooperation does generate goodwill between the parties, and having a purchaser with a binding contract but no financials to support it would only lead to delay of the inevitable. And while penalties might be chargeable for any delay in settlement, this might not amount to much for a vendor if the purchaser doesn't even have many assets that the vendor can seek to claim its costs on. If there is a tenant in the property as well, the vendor does need to understand in terms of notice times that need to be issued to the tenant to enable the valuer to be actually attend at the premises there. Next slide, please. The next one we move on to is owner builder works. So this is a vendor compliance issue, and is favorable to a purchaser if the vendor has not complied with the relevant legislation. So here we're looking at Section 137B of the Building Act, and also various ministerial determinations that have molded and shaped this. With regards to our experience on owner builder works, we've seen probably over the recent few years, owner builder works have become more prevalent. More vendors are seeking to update and modernize their homes. They're doing kitchen renovations, bathroom renovations, laundry renovations, to seek a higher sale price for themselves. And if they're cost conscious, then they might not always retain registered builders to undertake the works. So who does owner builder works apply to? It applies to an owner builder who is not a registered builder, an owner of land who also happens to be a registered builder, and mortgagees and executors as well of the people who are listed at 2A and 2B. So it is quite broad. The easiest way to identify if owner builder works are present is if there is a building permit, and the permit lists the owner of the land and not a registered builder as being responsible for the works. On a purchaser side, it is sometimes difficult to assess whether owner builder works have been done or not. What we actually do is we sort of look through real estate photos for the current marketing campaign and previous ones to determine if there has been a change in the property there. Or sometimes the ads do mention that, properties have been newly renovated and so on. So we need to have a few interrogations there of the property to determine if any of these exist. And also asking point blank questions of the agent, if there have been any works done, what are the time frame of those works as well. Next slide, please. So the key compliance requirements. So owner builder works will come into play if the property is being sold during the prescribed period. And if that's the case, then a condition report will always be required there. And warranty insurance may be required if the threshold is exceeded. Slide, please. So in terms of the nature of works, I've just taken an extract from the Section 137B in relation to the type of works that might fall under owner-builder ones. You'd see also point E is sort of a catch-all provisions in subsection D and E. So even if someone doesn't actually do the physical work, but sort of is more in a project manager type role, the management and coordination of such works is also treated as owner-builder works. So kitchen, laundry, bathroom renovations are the usual ones that we see, but also decks and pergolas. The building of those types of structures as well need to be addressed under these sections. Simple works, including just changing the cabinets or reflooring the property as well, those are also caught by owner-builder works. Next slide, please. So in terms of the prescribed period, so if a new home is being sold, if it's being sold within 6 years and 6 months after the date of the certificate of occupancy being issued, for renovations or extensions, it's the same 6 years, 6 months as well, but it's from when a certificate of final completion is issued. If none of these certificates are available, then it is 7 years from the date of an issue of a building permit, if there is one. If none of the top three exist in relation to a project, then it is 6 years and 6 months from the commencement date, for which the owner has to then do a statutory declaration to state what the commencement date is there of the works. This was brought in to sort of ensure that owners didn't just be lax about it and not obtain any occupancy or final inspection certificate, or, if no building permit was required, then there was actually no time frame to trigger the requirements for owner builder works. Next slide. So in terms of building warranty insurance that's required to be obtained, this is needed if the total works sort of exceed $16,000, or if there is a stage of work that exceeds $16,000 as well. Generally, if the works, if say a kitchen and laundry renovation are done within a couple of weeks apart, they would be treated as one project together. So the total costs for both of those would determine whether insurance is required. If there is a gap of, say, a year between the projects, they might be seen as separate stages. And so you can look individually at whether either of those cross the $16,000 threshold. And also the person that's undertaking the works as well. If it's the same contractor that's undertaking the works, that can also lead towards it should all be treated as one stage. The 3 stories exemption. So generally for residential buildings, no builder warranty insurance is required if the premises is more than 3 stories high. A basement that's used just for parking is not considered a story as well. So this exemption also comes across to owner builder requirements. Next slide, please. So with respect to the condition report that's obtained, it is limited just to owner builder works. So it is shorter. A vendor doesn't need a building inspector to identify all the issues that are there in the property, but just to confirm the status with respect to the owner builder works that have been undertaken. In terms of the validity of the report can't be more than 6 months old from the date of the contract. So it's important to remember this in the event that there is a delay in the sale campaign, or the property just is not able to sell for a period of time. It does need to be revisited if the 6 months has expired. In terms of if there are any defects that have been identified within the condition report, then on a vendor side, a special condition can be included to state that the purchaser is buying the property with those defects in an as-is condition, and they cannot seek to later terminate the contracts arising from those defects there. So on the purchaser side, you need to look out and actually pay attention to the condition report to see what issues have been identified there. And as long as the purchaser is comfortable with any defects that have been identified, then they can proceed with that there. Next, please. The next one is when there are older owner-builder works, there are various warranties that need to get included into the agreement between the parties. So with the Loren Stojcevski contract, these are included as boilerplates. So we don't actually need to worry about whether it's there or not. The issue does become that many vendors don't realize that these warranties are promises that they're making to the purchasers. So they're giving them warranties as to the quality of the work, whether new materials have been used, and so on. The condition report should identify if any of the works have been done, if any of the materials are new or have been reused there as well. So if there's any, improper or waterproofing that's been done incorrectly in bathroom renovations, say, the vendor then can be pursued for any damages that the purchaser might suffer if the bathroom was to leak. And so on. So basically the owner-builder regime is basically putting the owner in the same position as a builder in terms of these works to give a purchaser protection for that there. Next slide, please. So in terms of what will happen if the vendor fails to comply, the purchaser can terminate at any time prior to settlement, and the deposit must be refunded in full. So no monies can be withheld from the purchaser. This is in terms of the purchaser being able to avoid the contract, this is subject to the actions taken by a purchaser. So if they've behaved in such a way that they raised the issue and have subsequently elected to proceed towards settlement, then they can be treated as having waived their rights to be able to terminate the contract on this basis. There's also an ongoing liability to the agent for their commission. So even if the purchaser was to exit the contract and the deposit is fully refunded, a vendor might still be liable to pay the agent, as under usual exclusive authority agreements. The property is considered as sold there. And so the vendor might still have to pay the commission on this first sale. And if the agent then remarkets and secures a second buyer, there might be a second set of commission as well that applies for the resale. So on a vendor side, it might be necessary to look at what your exclusive authority is with the agent as well. So in terms of options for the vendor, if there's going to be issues with compliance, you can apply to VCAT for discretion to be able to seek an exemption from the requirements of Section 137B requirements. It is a higher threshold there that needs to be shown. There need to be exceptional circumstances there. So it is an option, but it's probably not one that you can actually rely on there. The case of Betts and Harmon did indicate that in terms of parties being able to contract so that a purchaser can basically forego its right to avoid the contract for any non-compliance by the vendor for owner-builder works. So we have seen in practice contracts that have these types of special conditions. And so when these are there, then we actually do need to do, purchasers need to do proper due diligence to understand if there have been any owner-builder works, and undertake their due diligence with respect to those works there. So not addressing owner-builder works can lead to negative outcomes for a vendor. So care must be taken to ensure that appropriate questions are asked from a vendor. So we all identify all works that have been undertaken on the property. And similarly for the purchaser side as well, if there have been such works, you just want to double check and make sure that there's no defects, and even have your own building inspector verify the information that's there in the condition report as well. So I'll now hand you back to Loren to discuss the Help to Buy scheme.
Thanks, Shubha. So since we're talking about conveyancing tips, it's worth mentioning the new Help to Buy scheme that started in December of last year. It's the latest government initiative to help people get into the property market with as little as a 2% deposit. So to wrap up the presentation, I'll give you a practical overview of how the scheme works and highlight some key points that purchasers should keep in mind from a property law perspective. So how it works, the Help to Buy scheme is a shared equity scheme, which basically means that the government contributes part of the purchase price in exchange for that share in the property. So for existing homes, that's between 5 and 30% of the purchase price, and for new builds, it's between 5 and 40%. The aim is basically to reduce the amount that people need to borrow, which then lowers your mortgage repayments and also stops you from needing lender's mortgage insurance, which can save you thousands. It's also worth noting that this scheme is different to the first home guarantee or 5% deposit scheme, where the government acts as a loan guarantor, because under the Help to Buy scheme, the government basically co-owns the property with you until you buy them out. Next slide, please. So who is eligible? The scheme has strict eligibility requirements. You have to be at least 18 years old, you have to be an Australian citizen, permanent residents aren't eligible. You have to have the money for a minimum 2% deposit, and also be able to cover the costs, other costs to do with the transaction, like stamp duty, legal fees, lender fees, inspections, valuation fees, and also land transfer fees. The property has to be your principal place of residence, so investment and commercial properties are excluded. A common misconception is that you have to be a first home buyer, but you actually don't. You just can't currently own any property, whether that's in Australia or overseas. Although there are some limited exceptions to this if you're a single parent buying out a co-owner or you're planning to sell an existing property shortly. You also can't exceed the income price caps. So this year it's $100,000 per year for singles and $160,000 per year for couples or single parents. You can't receive assistance from other government schemes or guarantees, though there are some state-based grants or stamp duty concessions that can be used, but you'll have to check with your lender whether you're eligible for those as well. You have to secure a home loan either through Commonwealth Bank or through Bank of Australia, and there are only 10,000 places available per year. Next slide. The property that you're buying also has to meet certain eligibility criteria. It has to fall within location-based price caps. So that's currently $950,000 at most in Melbourne and Geelong. And then in other places in Victoria, it's $650,000. It can be either a new or existing home, which includes a house, townhouse, duplex, apartment, unit, and the like. It can be a vacant block for construction or a property that's being demolished and rebuilt as well. But just note that there are some time limits and requirements for a comprehensive building contract, and the building has to be done within a certain time frame if you're buying off the plan. Next slide, please. So how do you participate? Applications can be submitted through your participating lenders, being either Commonwealth Bank or Bank of Australia. They assess your finances and then submit your application to Housing Australia. At the pre-contract stage, you get your conditional letter of approval from Housing Australia, and then your spot in the Help to Buy scheme is reserved for only 90 days, unless you apply for and then are granted an extension of time. When you get your conditional finance approval from your lender, then the next step is looking for an eligible property that you're happy with and that you want to make an offer on. We recommend that you get pre-contract legal advice, so then we can bring any issues with the property to your attention. And then if you're happy with the property, then it's best to make your offer subject to finance and building and pest inspection, like we've previously discussed. And then also note that Housing Australia will need at least 30 days between signing the contract and settlement, but your lender might actually have additional time requirements, so bear that in mind when you're putting your offer in. At settlement, Housing Australia contributes their percentage of the purchase price, and then their share is registered on title as a second mortgage behind your lender, rather than appearing as a co-owner with you. So that basically protects the government's investment while still giving you full control of the property. Also note that for stamp duty purposes, Housing Australia's interest is completely ignored. So that means that stamp duty is calculated as if you own 100% of the property, unless you qualify for some other concession or exemption. But that said, if you later buy out the government share, then you won't have to pay extra duty on that transaction. After settlement, you don't pay rent or interest to the government like you would with a home loan. Instead, over time, you can increase your ownership by making voluntary repayments of at least 5% of the property's value each time, and then gradually reduce the government share. If you sell the property, the sale price is based on the current market value, which means that when you eventually sell or buy out the government share, then they receive the value of their share at that time. So their proportion will change with any capital gain or loss. You also have ongoing obligations and have to remain eligible under the Help to Buy scheme. So the property has to keep on being your principal place of residence, and you need to maintain the property, pay outgoings like council, water and OC rates, and keep full replacement building insurance. If you decide that you want to renovate, then minor works that are under $20,000 that don't require council approval generally don't need Housing Australia's consent, but other works that are above that threshold will need pre-approval from Housing Australia. You'll also need to pay for evaluation before and after the renovations happen. So that makes sure that any increase in the property value any increase in the property that you pay for only benefits your equity share rather than the government share. And then Housing Australia will also review your eligibility at least every 5 years or sooner if your circumstances change, like say if your income surpasses the thresholds 2 years in a row. If that happens, then you might need to buy back part of the government share or even all of the government share. So overall, the Help to Buy scheme helps eligible purchasers to enter the property market sooner, but it comes with strict rules and ongoing compliance obligations. So careful planning and understanding your rights and responsibilities are essential to making the most of it and avoiding any pitfalls. Then I'll pass you back to Andre to go through the Q&A.
Thank you very much, Loren and Shubha. That was obviously very informative across a whole variety of areas. We haven't got any questions in the chat at the moment, but feel free to put that in. I might just put in some initial comments myself, just with what we're seeing at the moment. As you've heard throughout this presentation, buying or selling a house or any residential property has never really been as complex as it is now, with the amount of overlaying obligations and available schemes, both from a purchaser side and vendor side. There are certainly greater risks that we're seeing out in the marketplace in terms of purchasers looking for prospective ways out, or maybe not getting finance approved where they otherwise would have expected, or maybe have even been told that the finance would be easy enough to obtain. It's a lot riskier out there than it has been previously. Maybe a sign of the times, but also a sign of the rights that are there. So it's not uncommon for us to, from a purchaser side, get a call from someone looking to escape out of a contract. And obviously we're then checking through a lot of the obligations that we've addressed throughout this presentation to see if there have been any breaches that are out there. And conversely, from the vendor side, being able to defend what's been issued, obviously having asked all the right questions from the vendor to make sure that there's been proper compliance in the documentation. The other thing we're seeing sometimes is that deposits aren't necessarily being readily paid, so there needs to be a little bit more chasing up there from agents as they work through the transaction, just to make sure that there are those security amounts in place and that action is taken early if maybe an initial holding deposit was paid, but the balance of that 10% isn't quite making it into the agent's trust account in time. It's just important to be on top of that to make sure that when the settlement is expected, there's actually going to be the money there to complete. We're also seeing a lot of material disclosure issues coming up, as I guess we've touched upon throughout a variety of the topics today. Maybe it's a little bit of buyer's remorse, or maybe it's genuinely things that people have found out after settlement or even leading up to the settlement that would have impacted their decision to buy. Those issues have really ramped up, especially in terms of our litigious practice. It's just important to be aware. Sure, you've got to do your due diligence, but if something has been concealed from you, those do give you rights for compensation, and it's important to be chatting, obviously, with us or an advisor to make sure that you have an understanding of whether those are actionable grounds. Flip side, from a vendor perspective, if there's anything you are aware of about your property that might impact a purchaser's decision to buy that is not otherwise readily publicly available, it's important to have a chat with us or your advisor who's preparing the contract vendor statement to make sure that those issues, those disclosures have been adequately taken into account. There's just too much risk out there at the moment to be sort of sailing by and not giving these issues the consideration they deserve. Otherwise, you're asking for trouble down the track. So I think a little bit of a lesson just with where things are sitting at the market at the moment, to be careful to make sure that when a contract or vendor statement is signed, that it is going to stand up and that both sides know where they stand. So given there aren't any questions in the chat at the moment, I will hand back to Mitch to wrap it up.
Thank you, Andre, and thank you, Shubha and Loren, for going to such a great level of detail and coverage today. We do have more information on these sorts of topics to do with property law and property transactions. There's some examples there on the website of articles that the team here are constantly sharing and pushing out information that we're becoming aware of and developments in the law. So follow us on our social media channels if you'd like to keep abreast of things that we're sharing that might be relevant not only in property law, of course, but other areas of the practice that we deal with as well. I'll quickly mention our next webinar, which is coming up next month in March. another property related topic, but this time from the perspective of things that can go wrong and disputes that can arise. So you'll get to meet our colleagues in the litigation department, Graham and Sonali, who will be happy to take you through some of the things there and to be hopefully aware of and avoiding ending up in those sorts of issues. I'll quickly mention a book that we sell and is available through a website. It's by David Sharrock called Fighting for Enterprise Success Through the Eye of the Tiger. Some of you may be familiar with it already. It's available in a hard copy and an ebook. Particularly if you're running a business or an organisation, there's lots of useful material in there to help guide you along, including some materials from our own practice. So I do recommend that to you. If you aren't familiar with the book, check out the website there, fightingforenterprisesuccess.com. And finally, again, thank you very much for joining us. Here are the contact details again for the team who presented today, but always available to pick up the phone or send an email through to us. We're happy to have a chat if there's something we can help you with. So we'll leave it there for now. Thanks everyone from our team for sharing your insights today, and we wish everyone an enjoyable rest of the day. Thank you.